Welcome to PraDa Law Live. I'm your host for today's show, Jackie Mendez. Ladies and gentlemen, we have an excellent show lined up for you. Before I introduce our panel, I want to remind you that there's a number on your screen. That number is 888-88-LEGAL. We want you to call that number at any time during this live call, and we want to also remind you that that consultation is free, and so is the call. The call is also free. I'm going to go ahead and introduce our partners here at PraDa Law. First up, we have Daniel Silver.
Oh, hi. Pleasure to be here. Thank you for joining us tonight.
He's going to be covering some of our family law issues, and of course, we have Alexis Garcia.
Hello, Jackie. Thank you. Hello, and it's a pleasure to be here today.
And she's going to be talking to us a little bit about bankruptcy. And of course, I want to introduce the lovely Jennifer Pratt.
Thank you, Jackie. It's a pleasure to be here. And as always, call now. The number's on your screen. We have an excellent panel this evening. We're going to be talking family law, talking bankruptcy, and how the two intersect.
That's right. Again, 888-88-LEGAL. That's the number you want to call. Let's go right into the conversation.
Thank you, Jackie. And today we're going to be talking family law as well as bankruptcy. And I know we've talked about on the show how these two intersect, but today we have some actual cases that are happening right now in our office. And we want to tell you about these stories because maybe you identify, maybe you know someone that's going through something like this. But let's begin by talking to Attorney Silver. He was mentioning that he thinks it's really important that all of you know some of the challenges and some of the nuances about court. Do not be misled. Courts are open. Family courts are open, ladies and gentlemen. Here in Miami-Dade County, Broward County, we are going to court every day. And how is it that we're going to court, Attorney Silver?
Well, you know, times are changing, and we're not just walking into the courthouse and attending the hearings in person, but the hearings are going forward with Zoom technology. And these hearings are going forward. You have to have your witnesses prepared in advance, subpoenaed in advance, and clock management, it's kind of like a football game. You really have to be very cognizant of the time, because if you run out of time and you have a 2-hour hearing and you need a hearing continuation, well, you might not get a hearing continuation for months. So it's very important to be prepared, having your witnesses in line, exhibits, and all of that.
And I doubt it, but for those people living literally under a rock, what is Zoom?
Video conferencing technology platform. You hook into the Zoom video conferencing, and you are live streaming before a circuit court judge with a court reporter and a bailiff, and court is in session, even though you may be at your house in front of your computer screen.
So a Zoom meeting, it's like a Zoom meeting. It's like any other meeting that's taking place. So even though that everything's kind of slow, court is still going on, ladies and gentlemen. So that's why we want you to be prepared, and that's why we want you to call the number on the screen, 888-88-LEGAL. Let's go right into it, Jennifer.
And Attorney Garcia, what about bankruptcy? Can I file a bankruptcy? Are you going to court? Are there hearings right now? Are there 341 creditor meetings? How is the bankruptcy courts handling this COVID?
Bankruptcies are proceeding. You can file bankruptcies. You can have what we're doing now for 341 meetings. We're not going into court like before. And for 341 meeting, you never go into court. You actually go to a trustee. It's a room, actually. It's not a courtroom. It's a meeting room, pretty much, more so like a meeting. But we're doing these on the phone now. You come into our office where you've been, where you've sat with me before, where you've met with me, where you're comfortable, and we get on the phone and we call in your trustee and we proceed accordingly.
Because truth be told, I've been to those 341 meetings. Yeah. I mean, they're kind of scary when you walk in. They've got the big, FBI sign. So now you're saying, comfort, right, it's a little bit intimidating, but now you're saying comfort of either your home or in our office.
Well, yeah, I always recommend for our clients, we provide them a comfortable space in our office where they sit with me. They've met with me before and they can be comfortable with me. And we take all the questions over the phone. So yeah, you avoid the FBI sign, you avoid all the people there around you sitting with you, because when you do these 341s, pre-COVID, you're in a room and everybody there sits together and everybody kind of, watches as you go up for your individual
and can hear
interview.
your case.
And can hear your case, yeah.
Well, ladies and gentlemen, once again, 888-88-LEGAL, that's the number you want to call. I want to remind everyone that this show is live. So you can call in with any questions you may have. We're here, we're ready to answer, and we're ready to find those solutions.
Attorney Garcia, in the family world, I know at least here in Miami-Dade County, and I think even in Broward, we'll touch on that, Attorney Silver, there have been rules established, administrative orders that specifically lay out how evidence is being introduced in this new Zoom world, how evidence exhibits need to be provided at least minimum 7 days before a hearing. All sorts of nuances. Does the bankruptcy court court have any of these new rules that unless you are a practicing practitioner, you would know about?
Right. Well, yes, there are admin orders that come out consistently dealing with the COVID issues and how much longer we're going to be, practicing remotely. But yes, there are rules that you have to know regarding, and actually I was just reading the Beacon News today, which is a letter that the bankruptcy court issues almost quarterly, and they were giving tutorials, and explaining how the exhibits need to be uploaded prior to the hearings. You did have to usually get them in 3 days before. Now, it may change according to your judge. Make sure you properly label the exhibits, and they're uploaded through the ECF system accordingly.
Okay, well, we're definitely going to get back into the conversation, but I want to remind everyone that the consultation is free. That number on the screen, that's the number you need to call. The consultation's free. The call's free. You can call in at any time during this live session, and we're here. We're ready to hear from you.
And unlike, for example, criminal cases and some personal injury civil trials where you need a jury, you need a member of your peers, Attorney Silver, are trials happening in family cases? And do you need a jury? A lot of people may not know how family trials work.
Well, in marital and family cases, we do not have juries making determinations as to a best interest of a minor child. There are bench trials and the judges are proceeding with trials, and people are having their day in court. But our clients now aren't necessarily having to trudge to the courthouse, to go to a courtroom and wait in a courtroom and it's a different experience now because you're literally in front of your computer, but before your hearing, you and I will be meeting via Zoom, preparing for the hearing. But regardless, it's a different type of nervousness. You're no longer in a courtroom that you don't know, but you're in court. You're in a court setting. The judges take these Zoom hearings very, very seriously, and you can't just be sitting there in a t-shirt eating some popcorn, being nonchalant, because court is in session and judges are treating it like court is in session.
Wow, so I can't just, come in my PJs and into court and think that everything's going to be, okay, and the judge is going to love me. And
not only that, I literally a couple weeks ago had a motion calendar hearing where opposing counsel, it was his motion, and when we got on the Zoom hearing, the judge said, opposing counsel, you're not wearing a shirt, you're not wearing a tie. I'm going to cut off your hearing and wait until you put on a tie.
And before production cuts us off, I want to go ahead and take a short break. We're going to be right back with more with PraDa Law Live.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito. Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera de 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
And welcome back to PraDa Law Live. Once again, I'm Jackie Mendez, and I'm your host for today's show. We've been talking family law, we've been talking bankruptcy, but I want to go ahead and take it over to our partner here, Daniel Silver. Attorney Silver, what is the example that you were going to give us?
Well, unfortunately, with COVID, we're seeing a lot of losses of jobs and closes of businesses, and unfortunately, I've been getting calls from people who have a situation where both parties have lost their job. There's a minor child, they own a home, there's a mortgage, they have some credit card debt, but they have plenty of available credit. They also have retirement accounts, and they're really trying to figure out, how am I going to keep things afloat and get divorced at the same time? And it's a challenging fact pattern because there's no easy answers. However, there are better answers than others.
That's right. There are better answers than others. And I just want to remind everyone at home that that number on the screen is where you're going to find your answer, your solution, 888-88-LEGAL. That's the number you want to call for any questions you may have.
And Attorney Garcia, I mean, these folks that are in this situation right now, I mean, particularly when there's a status quo order, right? Say you are the breadwinner in the family. You have been paying all the bills in the house. Well, let me tell you, as soon as you're served or you serve your spouse with your petition for dissolution of marriage, you have to continue, unless ordered otherwise by the court, you have to continue to pay those household bills. And oftentimes what we see is that one party leaves the marital home, and so now you're supporting two homes. I mean, you couldn't do this before COVID, imagine now. So these folks that find themselves in this situation, I imagine they're gonna rack up a lot of debt. What are some alternatives? I know Attorney Silver mentioned possibly a HELOC on a house, but between that or getting credit cards to pay, I mean, what's the best alternative? And do we need to go see you after a divorce?
Or tapping into your retirement account early.
A lot of people do that. They do early equitable distributions, and they're getting money out just to pay bills.
Right. Here's the thing. Your retirement shouldn't be touched. They're protected under so many different areas of the law, whether it be tax areas, whether it be bankruptcy areas, you know, so you don't want to delve into that. That's created for your retirement, you know.
We can't give you tax advice.
Right.
However, we can certainly tell you that if you pull out your funds early, it's going to be income, there's going to be penalties.
Right, there's penalties and
for
things
tax
like that,
advice,
right.
you need to talk to an accountant, but generally speaking, pulling money out of your retirement account may not be the best option.
Correct. So, you know, taking a HELOC out at your house, on your home, again, that's just taking an asset that would be protected in the event of, not even if you don't file bankruptcy, creditors coming after you, you know, your homestead is protected in Florida. So there's so many reasons you don't want to further encumber your property. So, you know, if you have credit cards and you have them available and that's all there is, you know, you can use them. Don't be ashamed. You know, you can use your credit cards. You know, you use your whatever income you have to pay your necessary bills. The law allows you to use your income to pay what is necessary and what is required.
Okay, well, thank you for that, Attorney Garcia. The number on the screen, 888-88-LEGAL. We want to hear from you. The consultation, I want to remind you, is free, absolutely free. The call is free. We're here. We're ready to handle any questions you may have. We have the solutions.
That's right, Jackie. And Attorney Garcia, for those folks that have found themselves in a divorce, and now, you know, again, a lot of people think, I'm getting a divorce, I'm going to get half of the other party's everything. But what they don't know, Jackie, is that along with the good comes the bad. Because remember, two become one. You don't only share necessarily just the good, the income, the houses, the cars. You also generally have to split the debt.
The debt, exactly.
How can you help someone who has seen themselves, you know, have gone through the painful process of a divorce and now have found themselves, whether it was by agreement or by, and let me know if that matters, if it was by agreement or if it was by trial. In other words, the judge ordered this with a whole lot of debt from the divorce. How can bankruptcy help?
Absolutely. Well, a bankruptcy is going to discharge any unsecured debt that the individual filing for bankruptcy is responsible for. So if, you know, if the individual has their own debts, joint debts with the ex-spouse, one spouse files, that individual is the only person wiping out their liability. Now, if the judge ordered that the wife has to pay the husband's credit cards or vice versa, and the wife files bankruptcy, she cannot discharge her husband's debt because in the eyes of the creditor, the husband is still liable. That's something that would have to come up in the realm of the family court to address it.
And we actually have a case like that in the office where the parties were divorced. There was some credit cards, and one of the parties, let's say the wife, kept the credit card debt. It was in her name. The husband then proceeded to file a Chapter 7, forget about a 13, did a Chapter 7, wiped out the credit card debt, and now is taking a position in family court, Attorney Silver, that he does not have to pay, despite that being what the judge ordered, because they actually went to trial on that case. Is there anything this wife can do now to ensure that his half, quote unquote, of the debt still gets paid by him?
It's an interesting question, and point being, the final judgment in that case, the specific language will control. However, I want to bring up a point, and that's in a lot, 97% of our cases are resolved by mediation. And a lot of times we deal with credit card debt, which is in the nature of equitable distribution. And if you don't have a sharp attorney drafting your marital settlement agreement saying that if that other party doesn't pay the credit card debt, it needs to be punishable by contempt of court. Because otherwise, if you just have an agreement or even an order that's saying equitable distribution payments.
And I want to get back after the break and explain what contempt is, because it's very important. We'll be right back after the break.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote, ¿cómo? ¿Cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito? Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
Welcome back to PraDa Law Live. I'm Jackie Mendez. Once again, ladies and gentlemen, there's a number on your screen. Before we get back into the conversation, I want you to see that number, 888-88-LEGAL. That is the number that you need to call for your free consultation. The call is free. The show is live. You can call it anytime during this show. And I want to take the conversation back to Attorney Silver. We were talking about contempt. And what is contempt,
Thanks,
Attorney
Jackie.
Silver?
So, in a nutshell, contempt is a willful, intentional, with knowledge, disregard or willful contempt or a violation of a court order. And if you have like for example, if you have alimony or child support and that's ordered to be paid and it's not paid, it's contempt and you can be thrown in jail. However, if you're ordered to pay someone else's credit card debt in equitable distribution, it may be punishable by sanctions and enforcement, but it's not contempt.
Okay, well. Thank you, Attorney Silver. Jennifer?
So you mean like when you don't throw the trash out at home? That's what you mean, contempt? Okay. So, Attorney Silver.
It may be intentional and slightly willful, but
yeah, exactly.
Okay.
And I want to connect Attorney Garcia to this because we've actually been talking a lot this week about contempt. But one of the cases that we had earlier on in the year was actually that there was, and look, I'm not going to bore you with all the details, but basically one of the parties had to pay the other party some money, and usually would not be punishable by contempt. But Attorney Silver, one of the things that you actually advised me to do in that case, and I'm so glad you did, was to make the default in payment of one of the parties punishable by contempt. And why is that so much stronger when we go back to court very soon, versus if it was just sanctions? What's the difference between I may get sanctioned, which sounds like a horrible word, versus I may be held in contempt?
Well, If you're sanctioned, you may be paying the attorney's fees incurred for your violation of a court order. But if it's contempt and it's willful and you have the ability to pay, a court has the discretion to throw you in jail until you pay. You have the keys to your own jail cell. There's a purge, and if a court finds that you have that money in a retirement account or it's available to you, a court can hold you in jail until you decide to pay.
Good to know. Good to know. Thank you so much, Attorney Silver. Ladies and gentlemen, once again, that number 888-88-LEGAL. The consultation is free. The call is free. We're ready to hear from you.
So here's what we did in that case, though, and it was great because in that case there was a large amount of money, over $100,000, that was to be paid in equitable distribution. And we advised our client. We said, look, this is a good agreement. However, this agreement, the way it's written by opposing counsel, has no teeth.
Right.
And the court, in a property settlement agreement, the only teeth the court has, if it's not a domestic support obligation, is the teeth you write into the agreement. So we wrote the teeth into the agreement. We say, we're going to take this out of 61075, the equitable distribution statute, and we're going to put this into contempt land, where we say it's punishable by contempt, so she better pay. And she didn't pay, so now we have some teeth.
And exactly.
That's right. And, contempt can also come up in the context of bankruptcy. Attorney Garcia and I have been talking this week about a case where the person filed a Chapter 13 bankruptcy. And I'd like you to briefly explain to us what a Chapter 13 is. But also, at the same time, when they filed their bankruptcy, they stopped paying their alimony to their wife, okay? And so now they're in the Chapter 13, and the wife's counsel wants to move forward with a motion for contempt. And you were saying that you think they may be able to proceed.
Right.
Break this down to us, because it's very complex stuff, but I think people can relate to this.
To break it down quickly, once an individual files for bankruptcy, you get the protection of what's called the bankruptcy stay. That stops any collection efforts against the individual. Okay. Now, alimony is an exception to the stay.
As well as child support.
As well as child support, as well as paternity. A lot of family law issues, a bankruptcy will not stall those issues for moving forward.
Oh.
However, what some lawyers may do, and you can do in this case, is if she's scared of any violations, file what you call for a clarification order, or maybe just a comfort order that says, listen, we know he's in bankruptcy and we understand that. We're not going against the estate. We want our alimony, which is carved out an exemption to the stay relief order, and we want to proceed accordingly.
Well, let's remember, though, from the concept of or perspective of family law practitioner or state practitioner, when you're in the middle or you have a family case pending and all of a sudden a federal judge issues a stay, if you're going to try and get that domestic support obligation, it's best practice is to go file a motion in federal court and get that permission.
Well, the clarification, exactly. I represented an ex-wife in a bankruptcy matter. The husband filed for bankruptcy, and just to be safe, I filed my motion to proceed against the ex-husband, for her family law attorney, to proceed with the contempt and to move forward on collecting any alimony that was due.
Well, in this particular case, opposing counsel does not want to do anything in bankruptcy. They're ready to go and go to the contempt hearing. And, it appears that whether they have the comfort order or not, that's one thing. But definitely very important is that, let's assume the judge proceeds. Can they, under the bankruptcy world, can they proceed getting their order for contempt? Because it's for alimony.
Well, and yes, and it depends too. You want to make sure, though, like Attorney Silver pointed out, you don't want to violate the stay, so you don't want any language in there to deal with property of the estate. So you have to be very careful with that. And my advice would be too to get the proof of claim in, because if you're in a 13 and you're behind on your alimony as a debtor, you have the right to become current in the Chapter 13.
I want to talk to you about that in a second. I want to talk to you about that.
And before we get into that, I just want to remind everyone once again, 888-88-LEGAL, that number that's on your screen, that's the number you need to call. We're ready, we're willing, and we want to help you. Any questions you may have, we have some solutions for you.
And when we're having fun, unfortunately, production is saying the show is wrapping up, so we're going to have to leave this for the next show. But we're here every week. We're here for you. The number's on the screen, 888-88-LEGAL. We speak English. We speak Spanish. We have offices in Miami, Doral, Midtown. We're here to serve you, whether it's a family matter, a bankruptcy matter. And that's why an office like ours, full-fledged general law services to you, is so beneficial, because we have family attorneys, we have bankruptcy attorneys. Until the next time, we can't wait to see you again. Thank you for allowing us in your home this evening. Bye-bye.